Hello again, everyone. This is Rob Ryder, and today we're going to talk about judicial notice and book 'em, Danno. I just love that saying. Hawaii 5-0, if you don't remember. Judicial notice. For instance, I asked the court to take judicial notice of the fact that the plaintiff is a fictitious entity and its attorney has engaged in the unauthorized practice of law and is in criminal contempt of this state Supreme Court. It is my belief that in this matter the plaintiff's attorney is using a name not found on the roll of attorneys and has not appeared in his official capacity. I asked the court to take judicial notice of the maxims of equity and the prosecution's violation of said maxims by using statutes as instruments of fraud. In other words, there's this thing called judicial notice. And if you want the court to take judicial notice, and if you look at the definition of judicial, it has to do with things to do with justice, you need to tell them to take judicial notice. That's what it looks like. We'll find out. But for today, it's Sunday, January 4th, 2015, and I am Rob Ryder. Easiest way to get a hold of me, instead of trying to send me something through the WordPress site or through AOL, or through a video comment, is to send me an email to courtofrecord@aol.com. And my phone number is 616-712-6179. Donate, please. Donate. PayPal is my daughter, Ashley Rytlewski, @gmail.com. ASHLEYRYTLEWSKI @gmail.com. Why don't you pause the tape right now and write that down? And as soon as you're done watching the video, send a donation or put it in the mail. Get off your butt, go find your checkbook, cut me a small check. Come on, help me out. To Robert Rytlewski, 10955 14 Mile Road, Rockford, Michigan, 49341. And also we're going to be talking about certification of documents and of persons. Three very, very interesting things that we're going to see what they do this week, because I think that for sure this thing about judicial notice is a big deal. And when you look at it, common sense wise, quit thinking about what you think you know, just read what it says, say, oh, okay, let's go try that. That's what we're going to do. Reasons for this is, well, you read things like this in the Illinois Rules of Evidence. It says, on January 1st, 2011, by order of the Illinois Supreme Court, the Illinois Rules of Evidence will govern proceedings in courts of Illinois, except as otherwise provided in Rule 1101. What'd that say? What governs the proceedings in the court? Well, the Illinois Rules of Evidence. I guess we should really be paying attention to what they say as much as what the civil procedures say or the criminal procedures, because everything is governed by the Rules of Evidence, except as otherwise provided in 1101. Well, what could that possibly be? Except as otherwise provided in B and C, these rules govern proceedings in the rules of Illinois, right? And so this is talking about rules of evidence again. Just like the last rule in the Rule of Evidence, Chapter 11. Rules inapplicable. The rules, other than with respect to privileges, do not apply in the following situations. So we're not going to use the rules of evidence for certain things, other than with respect to privileges. Well, what's a privilege? Well, one of the privileges is you can at any point in any proceeding say, take judicial notice. But if you haven't said that, then even though these rules apply, they're not going to apply for some preliminary things, which is the beginning of every court case. So here we go. Preliminary questions of fact. The determination of questions of fact, preliminary to admissibility of evidence when the issue is to be determined by the court under Rule 104. All right, so what they're saying is the very first piece of paper in, right? Because it's a determination of questions of fact, so they're going to give them some facts, which is their complaint. But no evidence has been put in yet because it's preliminary to admissibility of evidence, so we're not going to look at the rules of evidence to see if there's any basis of truth to their fact. They're just going to write shit on paper, and that made it a fact. Okay, so for that, we're not going to use the rules of evidence, the preliminary questions of fact. The grand jury, they're not going to use the rules of evidence. Well, that's where all the indictments come from, out of grand juries. But they're not going to look at any evidence. They're just going to somehow produce a piece of paper and make your ass come to court. And if it's the grand jury, now it's criminal. And then number 3, miscellaneous proceedings. Proceedings for extradition or rendition. Preliminary examinations in criminal cases. Sentencing or granting or revoking probation. Conditional discharge or supervision, post-conviction hearings, issuance of warrants for arrest, criminal summons and search warrants, and proceedings with respect to release on bail or otherwise, and contempt proceedings in which the court may act summarily. So except for those things, we're going to use the rules of evidence, right? But we're not going to use them in probation hearings or discharge hearings or preliminary examinations of criminal cases, or anything that has to do with the grand jury, or to issue a warrant, or to issue a summons, or to get a search warrant, or so anything criminal, they're not going to worry about the rules of evidence. They're going to go do. That's how they're going to start. And then small claims actions. These rules apply to small claims actions subject to the application of some other. You have to go read that rule, see what that is. 286B. Forgetting that for just a minute. As you can see, even though the Supreme Court has said that we're going to use the rules of evidence in 2011, going to use the rules of evidence, except as provided here. Except as provided here, except for these reasons, for these we're not going to use the rules of evidence, and it has to do with pretty much everything criminal, and then pretty much everything to start a case, preliminary questions of fact. However, even though they're inapplicable, other than with respect to privileges. So it just comes down to what does it mean for the privilege, and that's you always have the privilege of telling the court to take judicial notice of any adjudicated fact. And we'll get into that in a second, because here we go. Article 2. So here are the rules of evidence. Judicial notice of adjudicated facts. This rule governs only judicial notice of adjudicated facts. Kinds of facts. A judicially noticed fact must be one not subject to reasonable dispute, in that it is either generally known within the territorial jurisdiction of the trial court or capable of accurate and ready determination by resort to sources whose accuracy cannot reasonably be questioned. So this is where you can bring a book of authority in that says, hey, this book says this, right? This is what Blackstone said about this. Take judicial notice what Blackstone said. That's one way you can do it. Continuing on. When discretionary, a court may take judicial notice whether requested or not. A court can do it whenever it wants to. But when is it mandatory? A court shall take, a court shall take judicial notice if requested by a party and supplied with the necessary information. You've got to give them the information to back up your statement. Opportunity to be heard. A party is entitled upon timely request to an opportunity to be heard as to the propriety of taking judicial notice and the tenor of the matter noticed. In the absence of prior notification, the request may be made after judicial notice has been taken. So what this is, really talking about, as we'll see, is they're talking about you contacting the court in some manner to have them take judicial notice of something to do with your court case, and then them issuing a subpoena to the other party to give them so many days to come in and answer why they shouldn't be found in contempt of court for doing whatever it is you say they did. And they got to go in and prove that you're incorrect. Right? So when you say that you don't believe that I asked the court to take judicial notice of the fact that the plaintiff is a fictitious entity and its attorney has engaged in the unauthorized practice of law and is in criminal contempt of this state Supreme Court. Okay, let's find out if he's correct. So one thing you need to do is you need to know that a fictitious entity, right, that it is contempt of court suing the name of a fictitious entity, and you'll find that by going to, I believe it's Black's Law Dictionary. under fictitious plaintiff or plaintiffs and it gets to fictitious. I don't remember how you get to it, but I've shown it before. It's easy enough to find, and it says in there that that is contempt of court. Per Black's Manual, but take judicial notice of Black's Law Dictionary, 5th edition, where it says, okay, and then as far as unauthorized practice of law, well, that has to do with them not following. If they're using a fictitious plaintiff, then they're in violation of their own laws, so it's the unauthorized practice of law. That and the fact that he's not doing it, he or she, in the name that's on the roll of attorneys. So tell them. So you can either do this in court, because you can do this at any step in the proceedings in a court case. And it doesn't matter if you already lost your property, because the court case is never closed. It's still open. You're still the defendant. Right? It never closed. That court case is still there. It's because they never finished the paperwork. All right. Let's go on. Time of taking notice. Judicial notice may be taken at any stage of the proceeding. Right? And so like a summary judgment isn't the end of a court case. It's a summary judgment. It's not a final decree. They never issue final decrees. I don't want to say they never do. Never, but we're not involved in them. In a civil action or proceeding, the court shall inform the jury to accept the conclusive of any fact judicially noticed. Right? So if the court says, take judicial notice of this, then that's the way it is. In criminal cases, the court shall inform the jury that it may, but is not required to accept as conclusive any fact judicially noticed. Now here's the thing about judicially noticing facts. Some facts don't mean a damn thing, but you can still have them judicially noticed. Right? But they're not going to. They're not really not the things that we want to point out. So I watched a short video of an attorney who was explaining this idea of judicial notice, and he wanted to judicially notice the court that it was 28 degrees on that day. Well, who gives a shit, right? Well, he does. He's an insurance attorney, so I could see where that would be a big deal for him. Yeah, the roads could have been icy, and they weren't rainy. If anything, it would have been icy. Right? So the courts are going to follow the rules of evidence, except in particular cases, and these particular cases are everything to do with a criminal case and everything to do with the start of a civil case. And unless you tell them to take judicial notice, because they don't have to unless you tell them, but when you say when mandatory, a court shall take judicial notice if requested by a party and supplied with the necessary information. Do your homework and give them the information, but don't give them a book. Give them a paragraph. Or give them the name of a book. Or the law you're going to be using. Or that you're invoking the maxims of equity, or whatever it is. As we'll see, these are all things that are considered to be adjudicated facts. And an adjudicated fact is a fact that has something to do with the case you're involved in. So it could be an adjudicated fact that they put a uniform traffic citation in your court case, and you're smart enough to look at that piece of paper and say, hey, according to this law, this doesn't have the right certificate on it. Right? Take judicial notice that this is the incorrect form. That's simple. But the easiest one to point out is take judicial notice that the other party's attorney isn't there in his official capacity. They're not using the name that's on their frickin' license. And Roe found out in Illinois that it's the clerk of the Supreme Court that has the original oaths of all the attorneys. You don't care that they have an oath as a judge or anything else, at least in the judicial part, right? What you care about is, do they have an oath as an attorney? Because if they're not on the roll of attorneys, then they're not authorized to practice law within the state. Cool stuff. All right, let's go on. What else we got? Here's another state. They're all about the same, right? Rule 201. It's the federal rule, and then it kind of rolls on through all the states. They all have a Rule 201. Some have a Rule 202. But Right kinds of facts. Again, judicially noticed fact must be, one, not subject to reasonable dispute. Jeepers, it reads just about the same. It is the same. When mandatory, a court shall take judicial notice. Right? Adjudicated facts. Factual matters concerning the parties to an administrative proceeding, as contrasted with legislative facts, which are generally and usually do not touch individual questions of particular parties to a proceeding. Facts that concern a person's motives and intent, as contrasted with general policy issues. Those facts must be found beyond a reasonable doubt by the trier of the fact before there can be a conviction. And the trier of the fact is the judge. Or he can try the fact and the law if he's sitting there by himself as the judge, but normally he's sitting there with a jury where the jury's the judge and he's the administrator. Adjudicated facts of which trial court may take notice if a fact is not subject to reasonable dispute. That should be simple enough. They are facts that, if a jury case, normally go to the jury. But we're not involved in cases with the jury. Normally you're sitting there in a frickin' administrative hearing. All of this is pre-trial stuff. You haven't even got to the point where you can put evidence in yet. You're not even in pre-trial. You're in an administrative hearing. A role of a U.S. court is to resolve the dispute that was brought before the parties before it, determining what happened to whom and when and how it happened and what the result is or will be. Is part of the adjudicative process by which the court reaches the resolution. These determinations establish the adjudicated facts of the dispute. Right? The things that are in the court case. That's what matters. So you go find the paperwork in the court case that they've done incorrectly, like the attorney didn't sign the paperwork, or there's an error or omission, or the fact that, hey, this attorney's name on this piece of paper isn't on the roll of attorneys. Adjudicated facts are specific and unique to a particular controversy. For this reason, the fact determination in one case is not controlling in other similar cases, even if all the cases arose from the same incident. Everyone's going to be handled on its own, and you are the one that needs to bring it to their attention, or there ain't nothing going to happen. Okay, legislative facts, which are general and can be applied to any party in a similar situation. For example, the facts used by a court to determine the legality of a tax increase levied against a single payer would be adjudicated particularly to that taxpayer's case. They have to have applied it to you before it matters. We don't care about all the other laws out there in law land. We care about the one they're bringing against you. And then you can say that I ask the court to take judicial notice of the maxims of equity and the prosecution's violation of said maxims by using a statute as an instrument of fraud. Right? And they're going to say, well, what do you mean by that? And you're going to say, this form is not the form that's in the book. Right? This is not the form that's been authorized to be used. Right? That the prosecutor hasn't appeared in his proper person. And it's the proper person that's going to be on the license. So, good stuff. Now, this is out of Michigan. This is pleading special matters, law or other jurisdictions. Notice in pleadings, a party who intends to rely or raise issue concerning the law of a state other than Michigan, a United States territory, a foreign nation, a federally recognized Indian tribe, must give notice, judicial notice, of the intention either in his pleadings or in a written notice served by the close of discovery. Well, you've never even made it to the evidence stage, so you're certainly not at the end of discovery yet. And so it just matters, do you need to put it in your court case or what? And they'll say, well, you could do it as part of your pleadings. That would be, to me, like a motion. Or in a written notice served by the close. So you just do a notice. You put a notice into your court case, judicial notice, and you put on there that you're going to serve it on the court. Because that's the one you're trying to take notice. You don't give a shit about the frickin' plaintiff. You don't have a choice. It's between you and the trier of the fact. And you're pointing out something about a fact, and he's got to make a decision, and based on that decision, A or B is going to happen. Transfer of action on finding of lack of jurisdiction. Oh, okay, so I wanted to find out more about what a written notice might be. And this talked about if they're transferring something from one clerk to another clerk, after been transferred, the clerk who got transferred to shall send written notice of this action to the parties. Okay, well that's not a court document, right? The clerk doesn't put court documents into a court case. They just handle them all. So this written notice isn't something that has to even go into court. You could mail it to the judge. Possibly. But I'd still go put it in the court, I guess, and do the service thing at the bottom, like you're, you know what I'm saying is there's no motion. This is just purely something that says judicial notice on it. Noticing the court, and you can put it in the court case so that it gets put into the court case and then mail a copy where it says on the thing, okay, now how did you serve it? Well, I served it by mail on the court at whatever the court's address is. Right? I don't know. I guess I would, you know, because I'm trying to think, well, who do you send this stuff to and what's the best way? You send it to the chief judge, who's the administrator of the court system for whatever it is. Like the chief justice of the state, he's the administrator for the state. The Chief Justice, this is interesting, I didn't realize this myself, the Chief Justice of the United States, right, he's not that's his correct title, Chief Justice of the United States, not Chief Justice of the Supreme Court. He's the Chief Justice of the United States. It's a whole different Ricky Lake show. Right, so they're acting like the chancellor, these Chief Justices, they're the administrator. They don't need to do all the court stuff. They can take care of behind the scenes, just like a chancellor in a court of equity. And in Michigan, we had courts of chancery to 1846, and then the courts of chancery got combined with the circuit courts, and they're supposed to be the same, and they have jurisdiction in both. And all we're trying to do is get them out of the law jurisdiction and into the equity jurisdiction. Well, if you understand that in common law, there's a great book. I have to go find that page. I may read a couple pages of it later on. But in common law, there's a whole bunch of things that make your stuff invalid. It's where Christ talks about the little tittles of the law, right? The little frickin' apostrophe. You don't put that on there, boom, your document's invalid. Spell a word wrong, it's invalid. Don't put a comma, it's invalid. Don't put the heading right, it's invalid. Don't use the right frickin' squiggly words, it's invalid. There's all sorts of stuff in common law that makes their shit invalid, and that was the whole idea. For them, that were in charge of the law, because that's how they could take your property. Right now, unless you're in the clique, you're not ever going to get anything in court, because you don't know the process. And so along comes the Court of Chancery, which was founded on the principles of the Catholic Church and Roman law. They had been Christianized by saying, well, we're going to take what they used to do with a praerator, and we're going to put the bishop in that place instead. And if you got a complaint that has to do with somebody doing something wrong, well, that's a sin, so it's under the bishop's jurisdiction. And therefore, you need to bring it to the church court. And again, this just goes back to old English law. Before the Normans came, the earl and the bishop sat together in court, and the bishop took everything that had anything to do with sin, and the earl had anything to do with just civil. So if two parties wanted to trade property, well, that would go to the civil side. But if this guy said, hey, he stole my property, well, then the bishop handled it. And then the Normans came and they got rid of it, and they put the church over in its own court, and they put the county courts by themselves, and they gave the Jews the county courts, and they started running them on a Talmudic law, and the rest is history. Here you are today. So how do we get out of all that? That's common law. That's what they want to use. We want to get out of the common law and get into the equity, which is really the common law, because that's the law that comes out of the Bible. That's just the New Testament. Axis of equity. Treat your brother like you treat yourself. All right, so you could, if If you want to, take judicial notice of the New Testament. Treat your brother like you treat yourself. Okay, what other ones we got here? Judicial notice. Facts and materials admitted under judicial notice are accepted without being formally introduced by a witness or other rule of evidence, and they are even admitted if one of the parties wishes to lead the evidence to the contrary. Oh, to lead evidence to the contrary. Even admitted if one party wishes to lead evidence to the contrary. Interesting. Okay. So, judicial notice and federal rules of evidence. So all this stuff really comes out of your federal rules, come out of your rules of evidence as far as judicial notice. Those that are generally known within the territorial jurisdiction, trial court, locations of streets within courts. Okay, locations of streets within court's jurisdiction. That's all you really need to have. That's why they want the street address. There it is. They always ask for the street address. Why? Well, that's what puts it in the court's jurisdiction. It's by putting that street address down there. Right, so this is really, those are capable of accurate and ready determination. That's why they had these things that they used to talk about books of authority, and that you could bring these books into court, and that, if you brought them into court, they were considered the law. And that's all they're saying is take judicial notice. But if it doesn't have anything to do with your court case, then it doesn't really matter, right? But the idea is you could find things that have to do with your court case or the situation you find yourself in a court case, and we can sit here and think of all sorts of ways, and I like to do it because I just like the mental exercise. But at the end of the day, the very simplest one is that dude over there is not in his official capacity as an attorney. The name that he's writing on paper, or not writing on paper because they don't sign anything, but they may have their name typed out, is not the name that's on the official roll of attorneys. And therefore, it's the unauthorized practice of law, and I don't need to say anymore. That's criminal contempt of the Supreme Court, and if that judge doesn't do something about it, he's in contempt of the Supreme Court, so you could tell him that. Judicial notice, burden of proof. I don't want to read any more about that. Let's get down to the nitty-gritty. Rules of evidence. New Hampshire, right? The kinds, again, the same thing. But kinds of facts and kinds of law, because that's the thing. You can also do, and you have to, and you need to do, take judicial notice of the law. A court may take judicial notice of a fact. A judicially noticed fact must be one not subject to reasonable dispute in that it is either generally known within the territorial jurisdiction of the trial court, being readily determination by resort to sources whose accuracy cannot be reasonably questioned. Okay, what about the law? A court may take judicial notice of the law. Laws include the decisions, the constitutional and public statutory law, rules of the court, such as the rules of conduct, regulations of government agencies, ordinances of municipalities and other government subdivisions in the United States. Right? So they can do it. A court may take judicial notice whether requested or not, but a court shall take judicial notice if requested by party and supplied with the necessary information. So if you don't do it, they don't need to take judicial notice of anything, and that's why it looks like it's a lawless court. Opportunity to be heard. A party is entitled upon timely request. Right? So if they agree with you, they're going to send this other party, this attorney who didn't appear in his proper person, a summons, a subpoena from the Supreme Court to come in and answer why he shouldn't be found in criminal contempt of court for putting in this piece of paper. Or they may say, oh, however, now as a trier of the fact, you can say, you're absolutely correct. That is contempt of court, or it should just issue an order for contempt of court. Time of taking notice. Judicial notice may be taken at any stage of the proceeding. You don't need to be in trial, any stage of the proceeding. And really, this notice is going to the court. It's not going to the judge. So I don't know why you couldn't give it to an attorney and tell him, take judicial notice or you're in contempt of court. Because he's an officer of the court. Right? That's the oath that matters. The one they took as an attorney, that is the original, is kept with the clerk of the Supreme Court. Okay, judicial notice is a strange procedure where an attorney makes a motion to have fact considered proved, even though no evidence was introduced. It is governed by Rule 201. Right? So what's a motion? A motion is somebody saying in court, right? Your Honor, take judicial notice. It was 28 degrees that day. Well, can you prove it? Well, yes. Here's the weather report. Okay, he took judicial notice. Right? There wasn't any paper involved. So you can speak the word in court. But if you don't speak the word in court and you write it, you may have to certify it or put it under oath or something else. But right, we'll get to that. But in court, you could just speak the word and then have something to back up what it is that you're speaking about. But, I said the generally known in the area. What are the generally known facts in the area? Where the local rules of court are generally known. Right? The Supreme Court rules are generally known. And so if you say it's in violation of the Supreme Court's rules of conduct of attorneys or whatever your book is called, there ain't much they can do. So it's strange, but it's wonderful. Let's use it. So facts and laws, statutes, case law, constitution, rules, administrative regs, local ordinances. The common law did not permit an uncodified local ordinance or international law. The common law did not permit notice of uncodified ordinances or international law. So they were never going to notice you, I guess, that they were using them. Apparently. I don't know what that means. All I know is you can use the laws. I ain't going to get too much in the details. Court records. The court may take notice of the pleadings, filings, and other content of the record in the present case. Right? So there's your adjudicated facts. What is in the case, that's the facts. And then you're going to also point out the law. And the facts are going to be the evidence. What's the procedure? If a party knows in advance that it will request a judicial notice, the request should be made in a pretrial motion with supporting documents attached and reasonable notice to the opposing party. Yeah, you could do it that way. But if it's unanticipated, a request may be made for the first time during trial. A party requesting notice must supply the judge with the necessary information. Okay, so you're requesting notice, and all it says to do is supply the judge with the necessary information. Didn't say anything about putting a motion in or even putting it in the court case. Okay, before taking judicial notice, the judge should notify the parties, giving them an opportunity to be heard. Unless you're pointing out that it's criminal contempt, and he will give the other party notice, he'll arrest their ass. They'll get noticed. You'll not know the hour is coming. Conclusive effect. Civil cases under Rule 201G, any fact judicially noticed in a civil action is conclusive. Contrary evidence will not be admitted. So when you say the attorney didn't appear as proper person and they take judicial notice of it, it's a done deal. Judicial notice other than a trial. Judicial notice may be taken by any court at any stage of the proceeding, e.g. on appeal, or at the very beginning. So you could just, and it said to the court, the judicial notice may be taken by any court at any stage of the proceedings. Well, there's an initial stage. The very first piece of paper you send as a complaint. But if you don't tell them to take judicial notice then, they're not going to do it at the beginning, right? That's what it said in that crazy ass shit we read in Illinois. That at the beginning, they're not paying any attention to preliminary questions of fact. miscellaneous proceedings, everything to do with a criminal case. All right, so if whatever your first piece of paper going in is, you need to say take judicial notice of the law. But since we're not out to sue people too much, although we're going to, I'll be pointing some people out, say, hey, this guy isn't using his license. Hey, that's why I'm interested in this, right? Because what I want to be able to do is say, okay, let's get the phone book out, start looking up attorneys' names, and sending a notice to the chief judge of that circuit. It does say that in Michigan, if you got a complaint about an attorney within the county, you're supposed to take it to the chief judge of the county and tell him to take judicial notice of your complaint, that your complaint is that this attorney is not operating under his name that he's supposed to be operating under. So this really has nothing to do with court that we go to. This is their private society where he's sitting there as their governor of these people that are all members of the bar. They all volunteered. Fucking A, man, you volunteered, then you're going to follow the rules. And so I'm going to point out to your governor that you're not following the rules that they put out. And it's his job to make sure you do. But I need to, judicially notice him of the fact. Because in the initial stages, they're not using the rules of evidence. And so they cannot pay attention to it. Okay, let's some more. Article 8, evidence. So, all general ordinances of municipal corporations, all ordinances of every county, all laws of public nature enacted by any state or territory. So those are acts, right? How do you know they're acts? Because they're enacted. We're talking about the public acts. Like the Civil Rights Act 1866, Section 2, where it says using color of law is a civil rights violation. All rules of practice, right? Per the rules of civil procedure, it says that they need to sign every frickin' piece of paper, and here's one that's not signed. Oh, and by the way, he's not here in his official capacity. It's the unauthorized practice of law. And so then as far as a judge goes, so this is how deep this gets. When you look at a judge is using a name with a middle initial normally, or a first initial, whatever, but it's not the name that's on his license as an attorney. Well, to be a judge, number one, you had to be licensed as an attorney, and the name he's using was never licensed. He was never a judge. Every case he's ever been involved in needs to be overturned, and the jail should open up. Something to think about and something to point out. Determination of such laws shall be made by the court, not by the jury, and shall be reviewable. Right? So the court's going to make the decision, and if you don't agree, you can appeal it. You can come in on a subpoena and answer the subpoena, but if you don't answer the subpoena, then they're going to, that's the thing about a subpoena, come in and show cause. It's a show cause hearing, show cause why you shouldn't be found in contempt of court for using a form that's unapproved in a court case. Any attorney may also present to the trial court any admissible evidence of such laws. But to enable a party to offer evidence of the law in another jurisdiction, or to ask that judicial notice be taken thereof, reasonable notice shall be given to the adverse party, either in the pleadings or otherwise. We don't need to use any foreign laws. We can just use their local rules, their local rules of court, their local rules of procedure, and above all, their professional conduct laws of their private society. All right, what else we got? Did I go through on this one? Now that one's done. Well, hey, if you can, now's the time. Donate. All right, gave you enough time. What else? What other one do we have here? Federal Judicial Notice. I think we looked at it. Rule 201, taking notice. So this is federal courts, right? What can they do? Taking notice. The court must take judicial notice if a party requested and the court is supplied with the necessary information. They may take it on its own, but they don't have to. That's why the courts look lawless. They don't have to follow any laws except the ones they decide they want to follow. And, well, there you go. The omission of any treatment of legislative facts result in fundamental difference between adjudicated facts. Adjudicated facts are simply the facts of a particular case. Legislative facts, on the other hand, are those which have relevance to legal reasoning and lawmaking process, whether in the formulation of a legal principle or ruling by a judge or court enactment of legislative body. That's all true except for the ones that have to do with your particular case. Even though they're legislative, they're going to be adjudicative because they had to do with that. If you point out a law as it applies to your case, that's what they're going to follow. But they do it a little bit different. Now, here's the thing. So, no rule deals with judicial notice of legislative facts. Judicial notice of matters of foreign law is treated in Rule 44.1 of the Federal Rules of Civil Procedure and 26.1 of the Federal Rules of Criminal Procedure. Foreign law. Right? So what's foreign to the court? We're not really sure. But this is what it says. A party intending to raise an issue of foreign law must provide the court and all parties with reasonable written notice. Issues of foreign law are questions of law, but in the deciding such issues, a court may consider any relevant material or source, including testimony, without regard to the federal rules of evidence. All right, so I'm going to leave that all for you guys to figure out. I'm not, that's getting way too deep for me. I just want to go and send something to the judge or have somebody who has to go to court this week for whatever reason, even if it's traffic court, just say, Your Honor, please take judicial notice that I don't believe the prosecutor is here in his official capacity as a prosecutor. That he's not using the name on the roll of attorneys. And that would be contempt of the Supreme Court. And see what the judge says. And if he says anything other than you're absolutely correct, say, well, Your Honor, Judge, you're going to be in contempt of court. And see what they say, right? I mean, what are they going to do to you? If you don't try it, you'll not know if anything can be done. Not really ready to do that yet. Okay, so you get the idea on the judicial notice. Right? It just has to do with the rules of evidence. You're going to find whatever it is about judicial notice for wherever you are. And that I've seen online. It's Australia. It's in the UK. It's probably any place in the Western world as far as that goes. Somewhere in there you're going to have something about judicial notice, and you're just going to tell them to take judicial notice. In America, it's in the rules of evidence. And as we saw in Illinois, it says that the rules of evidence govern the frickin' practice or the proceedings in a court case. Except, and it's the exception. But even in the exception, it said that you can use your privilege, and your privilege is to say, take judicial notice. So frickin' simple. Okay, now what else we got here? This is verification by certification. So you put this piece of paper in, you may have to certify it somehow. Right? You may have to put it under oath somehow. So forth and so on. And then when you really read these rules really, really, really close, this is what it says. This is in Illinois. In Illinois, a complaint, petition, answer, reply, bill of particulars, answer to interrogatories, affidavit, return of proof of service, and other documents or pleadings may be required or permitted to be verified. So maybe you have to, but you always can if you want to, because it's permitted. Right? It doesn't say may be permitted, it says may be required or permitted to be verified. When a court document is verified, the matters stated are stated positively or upon information and belief only according to the fact. The verified pleadings must be accompanied by a certification of the persons having knowledge of the matter set forth in the pleading. The certification must state, boom. So this isn't a law in Illinois. 735 ILCS 5/109. It's the civil procedures. And they require you to certify. And not only do they require that you certify thusly. Under penalties as provided by law pursuant to Section 1-109 of the Code of Civil Procedures, the undersigned certifies that the statements set forth in this instrument are true and correct, except as to matters therein stated to be on information and belief. And as to such matters, the undersigned certifies, as aforesaid, that he verily believes them to be the same to be true. Quotes, that right there and nothing else. That right there and nothing else. The certification must state. It's like saying shall. A verified pleading, when you've done it this way, or document may be used as if it had been sworn to under oath. As a result, an affiant who makes a false material statement is guilty of a Class 3 felony. So if you put this on your piece of paper and you sign as you're supposed to underneath it, blah, 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 well, now they either need to charge you with a felony for telling a lie, for basically guilty of a felony, man, or you're correct. But it had to have these words, right? If your piece of paper, if it doesn't have this on there, it doesn't have any standing in law. It's not going to be seen as being under oath. But if it does, a complaint, petition, answer, reply, bill of particulars, answer to interrogatories, affidavit, so forth and so on, yada, yada, yada. So we've sent all sorts of frickin' paper to Illinois in different kinds of complaints and never once put this on there. Okay, so this is how it's done in Illinois. Now, let me go, because there's a bunch of other places it's the same, and I don't want to forget to show this, because it isn't necessarily that way everywhere, so I'm going to get at. But this is how it's done in, make this bigger, 28 U.S.C. 1746. Whenever, under any law of the United States or any rule, regulation, order, or requirement made pursuant to law, any matter is required or permitted to be supported, evidence established or provided or proved by sworn declaration, verification, certificate, statement, oath, or affidavit, in writing of the person making the same, other than a deposition, or on oath of office, or oath required to be taken before a specified official, other than a notary public, such matter may, with like force and effect, be supported, evidence established, proved, by unsworn declaration, certificate, verification, or statement in writing of the person, which is subscribed by him, as true under penalty of perjury, and dated substantially in the following form. This is, we got two things we're talking about here, but first of all, so if executed without the United States, you would say it this way: I declare, or you certify, verify, or whatever. So I think you should certify. I certify under penalty of perjury, under the laws of the United States of America, that the foregoing is true and correct, executed on, put a date, and sign it. If you don't put that on your piece of paper, it's not going to be seen as being sworn to. Doesn't matter what else you put on it. Or, if executed within the United States, its territories, possessions, or Commonwealth, I declare, I'd say certify, under penalties of perjury, that foregoing is true, correct, executed, whatever. You notice something here? Without the United States and within the United States. And in the one without, if you're not in the United States, basically you're out of the United States, then it's under the laws of the United States of America. But if you're in the United States, it doesn't say here that it's under the laws of the United States of America. The United States of America and the United States are two different jurisdictions. And the Chief Justice, Roberts, is the Chief Justice of the United States, not the United States of America. Doesn't appear, because his official title is the Chief Justice of the United States. So under the laws of the 50 states, under the laws of the United States of America, is that the 50 states and the United States is actually more like the United Nations? I don't know. I just know they're two different jurisdictions, because this one, if you're without the United States, then it's the United States of America. If it's within the United States, then it doesn't say anything about the United States of America. So I don't even know which one to tell you is right. I'm just saying, well, I think that's something. Look at there. If you didn't know there's two different jurisdictions, or you wanted a way to prove it to somebody, 28 U.S.C. 1746. The deal is, you can put this stuff on there. So you just need to make sure what you're reading and see if it says United States or United States of America, whatever it is you're going to use, and then you would use whichever one of these is appropriate. But I guess I'd be using this one up here, the one within the United States, to send it to, if you want to send it directly to the Supreme Court, well, not the Supreme Court, the Chief Justice of the United States. So these different states have their different ways of doing this. And I found this by, it's a chart showing states that have enacted statutes similar to whatever. Here's another one. The fact that a notary public or other official empowered to administer oath is unavailable, and the following. So they want you to add that, right? Under the penalties of perjury, they got this blah, 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 and the fact that a notary, whatever. Right? But when you do this, again, it says if you make a false sworn certification, you're guilty of perjury. So they either got to charge you with perjury or they got to say you're correct. That's their choice. In California, they want you to put the date and place and the signature. And the place is like some place within the county or whatever, within the jurisdiction that you're sending it to. So Rockford, Michigan is a place, right? It doesn't have to be your street address. It's a place within the jurisdiction of the entity that you're going to send whatever it is you're sending to. Take judicial notice on a complaint, but you have to certify it. They don't necessarily want you to go to they're not asking you to go to a notary public. Because I don't know if the notary publics we go to are really the notary publics in the right jurisdiction, because they don't like to write things the right way. So this is how you get around them, is you just do it in your proper person and send it to them. Okay. That's enough on that. So, that was that, and that was that. Okay. What else do we have? Yeah, 735 ALCS 5-1-109. Verification by certification. Shall subscribe a certification, right? Shall subscribe. The person or persons having knowledge of the matter stated in the pleading, affidavit, or other document certified in accordance with this section shall subscribe to a certification in substantially the following form. Right? This is right out of the law that says in Illinois you're supposed to put this in your paper. So don't argue with them. Go try it. See what happens. Now, one last thing to point out is this is out of the Illinois Supreme Court rules. And professional service corporations, professional associations, limited liability companies, registered limited liability partnerships for the practice of law. Right? So we're not talking about all in the world, all types. We're just talking about the ones that have to do with the practice of law. And it says that basically, if they do what they're supposed to, they may engage in the practice of law in Illinois. So stop for a second. Not only can an attorney engage in the practice of law, a whole freaking corporation can. Professional service corporation. Professional association. That'd be like the bar association. Limited liability companies. That would be like, and registered limited liability partnerships. The limited liability companies. Well, limited liability company. Now, who is that? That is a special status you get when you register with the state. It's not national, federal. That's a state thing. Limited liability company. And then registered limited liability partnership is like if an attorney has an attorney firm where he uses what looks like his name and the name. Well, and he says he's partners with somebody else. Then I don't know if I had the example up or not, but we had one that shows. But it doesn't really matter, because what matters is if you're looking at a business card and it's any one of these things here, then it may engage in the practice of law in Illinois, provided that each natural person shall be licensed to practice law who is a shareholder, officer, or director of the corporation. Well, that would make sense, except the secretary, yeah, because you need a business guy. Member of the association, member, manager, if any, of the limited liability company, or partner of registered limited liability partnership. Right? So the people have to be for the corporation to be. It's reasonable. Excuse me, and this is kind of a continuation, but this where it gets good, blah, 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 all these different people can, but what about it? However, no corporation, association, limited liability company, registered limited liability partnership shall engage in the practice of law in Illinois or open and maintain an establishment for that purpose in Illinois without a certificate of registration issued by this court. And this court would be the Supreme Court of Illinois. So it doesn't matter they got shit from the Secretary of State. No, it has to come from the court. And if they can't produce a certificate of registration issued by the court, then guess what? We call that the unauthorized practice of law. And now it ain't just one attorney, it's the whole attorney firm. And what does that mean? That all shareholders, members, or partners shall be jointly and severally liable for the acts, errors, omissions of the shareholders, members, partners, and other employees of the corporation, association, limited liability company, or other registered limited liability partnership arising out of the performance or of professional service by the corporation, association, limited liability company, registered limited liability company, partnership, while they are shareholders, members, or partners. In other words, I asked the court to take judicial notice of Supreme Court Rule 721, Professional Service Corporations, which says that in order to practice law, the corporation has to have a certificate from the court, and if they don't, well, then that's the unauthorized practice of law. I don't believe they have a certificate. Now, what makes that a fact? When you put it into court, it's a fact. You said it. Doesn't matter if it's true or not. You said it. Well, now they can give the other guy a chance to, well, what do you have to say? Right? That's the beauty of it. You need to say it. And if you're not going to say it out of your open mouth, right, you still need to say the word, because everything in the New Testament is done by your word. And so you need to say the word, or you need to write it and swear to it, so it's your sworn word, right? A memorial to the event. So let it be done, so let it be said. How's it go? So let it be written. So let it be written, so let it be done. Make a memorial, then go do it. All right? You got to think it first, say it, make a memorial, execute it. So we need to get the part of we thought about it, we need to say it. There we go. Put it in writing, they can execute it. And so that attorney firm that just came to foreclose on you by one of their attorneys, and they have a business card, and you go and look at that corporation name on that business card, and you contact the clerk of the Supreme Court to see if that business has got a certificate, or you call them because they're supposed to have it and say, I need you to supply me with your certificate of registration of your business with the Supreme Court. Got 7 days, and they don't. Whatever time you want to give them, I don't know, administrative process. If you guys want to do the whole 30 days, go right ahead. And then take it to the court. Right? But either go check for yourself if they have it, or contact the attorney firm and say, I need a copy of your certificate of registration with the court to allow your corporation to practice law. And so, every state's going to have something like this. In Illinois, it's the Rule 721, professional service corporations involved in the practice of law. All right, so registered limited liability partnership, practice of law. I think that's about it. There's a lot more blah, 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 but that's the main thing. But this talks about the certificates, so this is another rule, 722. Proof of financial responsibility. Funds that are specifically designated and safeguarded or segregated for the satisfaction of any judgment against a limited liability entity. See, because these guys, it's all wager of law, right? They're putting a bet that they're going to get your property without you catching on to what you need to do to stop them from getting your property. It's trial by wager. And that's what their bond is for, and they need to put this money in an account and so forth. So when somebody comes to foreclose on you, they already have all the paperwork for ownership of the property, and they're trying to get the ownership and keep it from you. And they put it in this segregated account that they have to certify yearly with the Supreme Court of their state, in which they keep funds of their client and third parties. Well, a client, but as third parties, who would the third party be? Well, that would be you. It's your property. Right? So they have your property, the ownership to the property for a foreclosure of whatever it is. They have it. And it's in your name, and they're trying to keep it from you. And so that's what this account has to do with. And so after you've shown by judicial notice that the plaintiff, because in a foreclosure the plaintiff is a fictitious entity, it's not the bank. Just frickin' Google the name that's in the plaintiff box and it doesn't come up. Well, not that it won't come up. You won't be able to go and find a certificate of good standing for them. They don't exist as a corporation. It's a made-up name. And this attorney is representing a fictitious entity. Right? What he did, he's a debt collector who bought the debt, and he's got to sit in the account, and he's trying to get you to sign it over to him. Well, that's your property. Remember that on the deed of trust or the mortgage, the bank never signed the damn paperwork. So you don't have a contract with them. You can't have a unilateral contract in business. It just doesn't work. Only you signed it. So it looks like a gift or donation as far as that goes, or it's just an unfinished contract. Business contract. And it is, and the evidence of that is all the time you've been making payments, you're making them to an escrow account. And escrow accounts are only used for one reason. Well, I can't say only one reason, but it's a third party. It's going to a third party. It didn't go to the people you're supposed to have the contract with. Well, why isn't it going to them? It's because the contract was never completed, so the escrow account is holding it. And eventually when they get to this foreclosure, this is all going to be about the closing agent now complaining he never got his payment, his fees for doing the closing, because you and the other party never came to an agreement. And nobody ever paid him his attorney's fees. Blah, 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 blah. Now, none of those words are going to be said, but that's what it looks like when you just look at all the way through down to, okay, what are they doing? Boom, 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 boom. And, you know, you don't have certain pieces of paper you should have right now, and you go find out why by looking deeper. And I've done enough videos on this stuff that I'm not going to talk about it too much more, but it's what happens. So you need to point out their error, and then point out that you believe this man has got your property in his bank account. Well, that's big stuff, man. So anyways, the attorney firms have to have this certificate of registration, right? Or it's the unauthorized practice of law for the whole frickin' firm, and I don't care how big they are, it's the unauthorized practice of law for that firm, and they're going to have to be shut down immediately. I guess. We'll find out when somebody gets up and does it. You know, but all I can do is point out what it says, and this is simple enough stuff that you can do it in a traffic case or foreclosure. You don't need to do anything. Just stand up and say, Your Honor, take judicial notice of the fact that the attorney for the plaintiff is not here in his official capacity, that you do not believe he's using the name that's on the roll of attorneys, and you wish to have it investigated. Because you believe he's using an instrument, he's using a statute as an instrument of fraud, and that's against the maxims of equity. Something like that. And just let's see what they say to that. And whether it works in the courtroom or not, then okay, we're going to try it there. But send it to the chief judge in writing with whatever kind of verification or certification you need to do. I wanted to point out, okay, I didn't really go over this. So this is how it's done in Illinois. Now in Michigan, this is how it's done. Right? Ours is a little bit different. The signature of attorneys, verification effective sanctions, verification, okay, this, I just read the whole thing. This rule applies to all pleadings, motions, affidavits, other papers. Yeah, okay. Except when otherwise specifically provided by rule or statute, a document need not be verified or accompanied by an affidavit. Okay? Well, they have a thing called a verified complaint that we're supposed to put in. I guess that means it needs to be verified. If a document is required or permitted to be verified, it may be verified by oath or affirmation of the party, or of someone having knowledge of the facts stated, or except as to an affidavit, which isn't, you know, and I'm not too concerned about the affidavit thing. I'm more interested in the verified complaint, because I want to put a complaint in. So except, so it has nothing to do with that, including the following signed and dated declaration. Right? So I don't need to go find a notary public who may not be in the right jurisdiction and have to worry about it. I could just write on the paper, in Michigan, I declare that the statements above are true to the best of my information, knowledge, and belief. Now that's exactly the words that they put on the uniform traffic citation here in Michigan. The problem for them is they don't sign the damn piece of paper. Right? They don't use their proper person on the paper. They put Officer Smith, and that ain't cutting it. In addition to the sanctions provided under Subrule E, a person who knowingly makes a false declaration under Subrule B, 2B, right? So where are we? There's B, there's 2, and there's B, which is the I declare, okay? May be found in contempt of court. Well, excellent. If they don't find you in contempt of court, they must agree with you. You got to put those words on there. Signature. Every document of a party represented by an attorney shall be signed by at least one attorney off record. Please just go look at the paperwork if you're in a foreclosure or something, or, you know, go look online at foreclosure paperwork, or hell, go watch my videos about foreclosures, and you'll just see that they never sign anything. There's always blanks on paper. Right? Go look at any court case. There's always blanks that haven't been signed on paper. Right? Where the attorney's supposed to sign because it has his name printed underneath there, but there's no signature. Right? So they didn't sign it. So judge take judicial notice that the attorney for the plaintiff didn't sign this paper. Oh, and by the way, he's not here in his official capacity and blah, 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 blah. What does it mean, though? Failure to sign. If a document is not signed, it shall be stricken, unless it is signed properly after omission is called to the attention of the party. Right? Court take judicial notice because, again, the attorneys are officers of the court. So take judicial notice that you didn't sign your paper, and that's an omission. Right? Sign the paper, or it has to be stricken. Effective signature. A signature of an attorney or party, whether or not the party is represented by an attorney, constitutes a certification by the signer. So whether you sign it or the attorney signs it, whoever signs it is certifying. You've read the document to the best of your knowledge, information, belief, informed after reasonable inquiry. The document is well grounded in fact and is warranted by existing law. Right? So in fact and law, it's in good faith. Argument for the extension, modification, reversal of existing law, and the document is not interposed. Blah, 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 blah. Sanctions for violation. If a document is signed in violation of this rule, so if a document is signed, first, this is why they leave them blank, because if it is signed in violation of this rule, the court, on motion of a party or its own initiative, may impose upon the person who signed it an appropriate sanction, such as contempt of court. Sanctions for frivolous claims and defenses. In addition to sanctions under this rule, a party pleading a frivolous claim or defense is subject to costs provided by yada, yada, yada. So again, if you... this is why they don't sign the paperwork. Because if they did, well, then they would be guilty of a frivolous claim. And the way they have it running is, the very first parts, they don't require, they're not going to follow the rules of evidence unless you invoke the rules of evidence, and you're going to do that by just telling take judicial notice of the adjudicated facts in the case. And those facts in the case are the things that are in your case, having to do just with your case. Could have things to do with other cases, but they definitely have something to do with your case. And it's everything from the attorney firm isn't certified with the clerk of the court, so the attorney firm is in contempt of court. Right? The attorney isn't using his proper name. He's in contempt of court. Oh, and they committed perjury. That the officer, whoever did this piece of paper that's in the court record, is guilty of contempt of court. False personation of a peace officer. The prosecution is guilty of contempt of court. But you need to point out judicial notice. So it looks like we're going to rock with that this week and see where we go. So good luck with it. I hope to hear from somebody that they've at least tried it. We'll see ya. Take care.